Good evening, everyone. Thank you for coming. We are very grateful yet again to have Charles Fair of Fair Legal with us. My name is Vanessa Flotbush-Brahmakshatriya, and I volunteer with the Canadian Centre for Men and Families, Alberta. Charles Fair has been practicing law for over 30 years and founded Fair Legal because he is passionate about helping others, ensuring that their rights are protected and that they are treated fairly. Fair Legal deals with criminal, family, and civil litigation matters, and Charles is generously volunteering his time with CCMF Alberta to deliver monthly webinars on topics of common concern to the population that we aim to serve, namely men struggling due to intimate relationship breakdown and turmoil, and also the people who love them. At CCMF Alberta, we are committed to meeting men where they're at so that they can feel heard and validated and have conversations that matter to them. We help equip men to manage stressful situations, rebuild their lives after relationships fail, and stay connected with children. We recognize that providing mental health support for men leads to optimal parenting outcomes, a reduction in family violence, and lower rates of suicide. Please keep in mind this is an educational offering. It is not legal advice, but we do love to have your questions. So please use the Q&A function in Zoom. And during the Q&A period, I will read them out loud for Charles to answer. Please keep your questions related to the topic of this webinar, and don't share too many specifics of your case, partly because this will go up on YouTube and you don't want to disclose too much, but also the more specific you are, sometimes the harder it is for Charles to be able to answer, right? Keep your questions general. And if you are looking for additional supports for your mental health as you navigate your legal challenges, please visit our website and read about our other programs. So I'm going to ask Catherine to put a link in the chat to our programs page, which is ccmfalberta.ca/programs. And with that, over to you, Charles.
Great. Thank you very much, Vanessa. I don't seem to see any videos here on my own screen. Anyway, so thank you very much. This is great to be here helping out with the CCMF again. You guys really do have a great mission, greatly needed in the community. And I'm sure the courts and mediators and arbitrators that are out there really appreciate when the men that are coming before them have more emotional support. So I just wanted to throw that in there. Great shout out to the work that you guys do. And it is a great pleasure of mine to be able to get on screen and talk because I love to talk. That's why I'm a litigator, I guess. So in any event, yeah, tonight's topic is separation of matrimonial property and who gets what. And we're going to I'm going to guide you through some of the more critical aspects of this family law, which is dividing matrimonial property. So whether you're preparing for separation, curious about your rights, or already in the thick of a dispute, this session hopefully will provide you with some valuable insights. Here's what we'll cover today. Hopefully, what is family property and why can't I call it my own? What is exempt property? What property do I get to keep as my own? And some ways that exemptions can be lost. Wait, what happened to the property that I thought I could keep? And what do I have to disclose? And do I really have to disclose my exempt property too? Yeah. Okay. How can I protect my property rights with agreements? And then we'll talk about some unique situations. You know, there's a whole course, probably a whole course could be taught on this stuff. So this is going to be a very big overview of this topic. So we're not going to be able to cover everything. We'll wrap up with some key takeaways and give you an opportunity for some questions. And again, remember, like Vanessa said, this isn't legal advice. This isn't a presentation that is about every single aspect of matrimonial property. I might miss some big ones. The law is constantly changing, and quite frankly, I just don't know everything. And so we're going to give you a good overview of the topic and maybe some tips along the way. So first off, let's talk about what is family property. And essentially, it is assets acquired during a relationship. And there's a presumption that it's shared equally upon breakdown. So it's only the things that are acquired during the course of the relationship. And why is that? Well, it's because there's this presumption that both parties are contributing to the acquisition of that property. And you say, well, wait, I'm the one who's doing all the work. I'm the one who's bringing home the bacon. And all she's doing is sitting at home. Eh, Maybe we don't want to say that, but uh, the reality is that the law presumes that both spouses are contributing and they're contributing in different ways. And that's why, fundamentally, why all the property that is regarded as family property gets divided. So some examples includes homes, vehicles, investments, household goods. When it's money, if it's a thing that has value, that's matrimonial property. Had a discussion today about whether frequent flyer points are property. Yes, they are. They're probably not a big deal, but they could be, right? So that's just a little example of some kind of weird piece of property that somebody might not have thought about. And we'll cover some of some of the bigger unique situations later on in this presentation. So the key points on this is that it applies to legal marriages and common law relationships, and it's governed by Alberta's Family Property Act. It used to be called the Matrimonial Property Act. A few years ago, it was extended to both, um, not just married partners. So that raises some myths. So yeah, myth one: only married couples, and this was true up until a few years ago that um, uh, family property was only divided between married spouses. And the courts were pretty clear about that. It wasn't that common law spouses had no rights, it's just that they were harder to prove. A very famous Supreme Court of Canada case had a 40-year relationship between the husband and wife, or so they weren't married, they weren't legally married, but they owned a farm. He was the farmer. He worked the farm. She was the homestead keeper. She raised the kids and kept the homestead in order. And after 40 years, they had a breakdown, and she got half the farm, even though they weren't technically married. That was under the notion of constructive trust, which is something that you hear occasionally now, or you'll read it about it in the cases. But now, a few years ago, the Alberta government said, it's not really fair that unmarried people don't have those same rights as married people, and they've got to jump through all those very difficult hoops to establish constructive trust. So the law has been extended so that unmarried partners also have rights, but you have to meet the definition of being an adult interdependent relationship or adult interdependent partners, AIP. We call them in the legal business APEs, but that's maybe not politically correct. So in any event, that's what we say, APEs. So myth number two, equal split is, as I mentioned earlier, it is the presumption, but it's not always the case. And really, when you think about it, dividing up assets exactly equal is perhaps a fool's exercise. If you think about how you divvy up a piece of pie for dessert for the children at the dinner table, trying to get the pie exactly equal is very, very difficult. So the same is true in this matter. Myth number three is all property is divided, and no, it's only family property that's considered in that division. And there's questions about what that family property is, and that there are exemptions, and we're going to talk about that. Myth number four, I put it as do it yourself is a good idea. Sometimes you can actually do it yourself. And even though I'm in the business of providing legal services, you can do some of it by yourself or with your partner if it's a low conflict situation. However, if it's an agreement that needs enforcement, you're going to need to have a lawyer because it's mandatory under the Family Property Act that both parties have independent legal advice and the lawyer signs an acknowledgement that advice has been explained to each of the parties. So that's so having your own independent lawyer for each party, having their own independent lawyer is mandatory if there's going to be any kind of enforcement of a matrimonial or family property agreement. So um, that's all I'm going to say on that. So let's talk about some exempt property. So this, I got a bunch of images. Thank you to Canva for their AI process. This is computer AI generated images. So don't look too closely. You'll see some weird things like there's a looks like there's a headless person in this one. In any event, this is an inheritance. Oh my God, really? So an inheritance is exempt property. Probably this is good news for the spouse of this person that what you want to share that, but who knows? You know, there might be some values in the unseen inhabitants in that. The point is that if you receive a gift from a third party, which includes inheritances, that is exempt. Now, it's only the value of the property when it's acquired that is exempt, or at the time of the value of the property. So if it increases in value, like if this old ramshackle piece of property is improved, the value of that improvement would be shared matrimonial or family property. So that's that first one. So here's another one. Uh, no, not the people, but the toys. What do you think? Is that exempt property? Well, it's family property if it's acquired during the course of the marriage or the relationship. But if you came into the relationship with the toys, then they are yours and they are not subject to division by the courts. Sometimes that can be a little bit of a sore point, depending on how the toys were used during the course of the relationship. All right, so here's another one. I just put this one as lottery winnings, and I'm just going to say if you got lottery winnings, um, that's going to be a particularly tricky subject. There was a party in Manitoba a number of years ago who thought, oh, I'll try to get away without disclosing, winning the big one shortly after, or maybe shortly before the relationship ended, and decided that he wasn't going to disclose it. But when it was discovered, he was made to turn over the entire winnings. Again, the other point though I wanted to make here is just because something is given to you in the form of money, it does not change the fact that it is a thing acquired during the relationship and is presumed to be equally shared, but it really depends on what it's for. So we're going to talk about some of those things as we go here. Here's another one. Oops, that picture is kind of out of place there. AI generated cats and dogs, pets. Yeah, they're exempt if you brought them into the relationship. They're not exempt if they are if you've acquired them during the relationship. However, dividing the cats and dogs is a little tricky, and it's not just about money. Sorry for the misplaced. I can't blame AI for the misplacement, but the AI is certainly the responsible for that weird looking critter in the background. And some more AI generated children. No, children are not property. You might think they are, but no, they're not. So we're not going to talk about how you divvy up the children. We're not talking about property parenting issues at all in this thing, but I just thought, because sometimes people get kind of property mentality when it comes to children. No, they're not. Again, don't look too closely at the girl in the back on the left-hand side. She doesn't look quite normal, does she? Okay, well, that's AI for you. Good. All right, so now we're gonna go on to one. Here's another interesting one. I don't want to talk about this a lot, but when you think about it, the wedding rings are a gift. So it's an asset, but it's a gift between the parties. And now the question is, how does that get dealt with? And that one is, we don't see it too often in disputes. I think that I suspect, I'm not quite sure, but I'm suspecting that the parties just want to leave that one well enough alone, and maybe it's just not enough money at stake. But it can be a big issue for some parties. I run into it every once in a while, so I thought I would throw it in there as a somewhat of an unusual matter. There are some kind of uh, rules that don't have to do with family property division, but there's some kind of customary rules about uh, what happens to an engagement ring if the marriage doesn't go through. And it kind of depends on who breaks off the relationship. Um, but you might not get the ring back if you um, gave it to the girl and then broke it off. She's probably entitled to keep the ring. But giving the ring back is often a really good way of signaling to the giver that, yeah, the gift is not appreciated and sorry, we're going to move on. But in any event, that's that. So I just thought I'd throw that in as a little weird piece of property on there. And the last one I would talk about is money that you get as a result of a court judgment or insurance proceeds. And again, this is where it's really going to depend upon what the damages were for. If it's personal injury damages that are compensating you for pain and suffering, um, or out-of-pocket expenses, that is not presumed to be family property. But um, if it is to compensate you for income and possibly for out-of-pocket expenses, it may be regarded as family property and get divided in some way. So um, it's a point to remember if you are in a personal injury situation when you're negotiating a settlement to consider how the settlement is being calculated, and this I'm not sure of any whether there's any case law on this, but it does strike me that a party wishing to share in the personal injury damages might be entitled to poke at the underlying calculations to determine how much of the award is actually related to income loss. The other thing, obviously, is if there's insurance proceeds from a property loss, like a replacement of a car that would otherwise be matrimonial property or family property, or the house burns down and there's a big settlement check. Yeah, that's family property, even though it's insurance proceeds. So don't be confused by the label. The idea is that it is something that is um, uh, to be divided, and the courts are trying to figure out what's fair and equitable in the division of the matrimony of the family property. Sorry. But I keep saying matrimonial is because for many, many years, I've been practicing over 30 years. And for most of those 30 years, again, property was only shared between those who were bound by in matrimony, in other words, married couples. So a lot of us older lawyers just keep saying matrimonial property, but it really is family property. So now, let's talk about how some exemptions can be lost, and this can really suck. Um, so let's think about this middle one, joint gifts. So you got a young couple, and they've got one of their parents has got some money that's some extra money, and they're willing to support the young couple and give them some money to buy the house, and the house is put in joint names. Further complicated by the typical requirement of banks that the money be that the parents sign a gift letter saying that this is not a loan, it's a gift. But the real key point here is that the house is put in both spouses' names. So even though one or both parties' names, even though one party is the money is coming from their parents, the fact that it's joint now makes it a gift to both parties, and you can't kind of undo that gift. That's very difficult, and that can suck. If you thought that maybe there was an exemption for the gift, and sometimes a substantial gift that your family member has bestowed upon you, unless they did that before the relationship started. Okay. Now, untraceable spending. Well, that's kind of a fancy word here. So here's where I had one case where um, the wife received an inheritance and the husband received an inheritance. The wife put her money into a separate investment account, and it wasn't a lot of money, but it was maybe 50,000, say. And the husband also received a similar sized gift. And he was very supportive of the relationship and the family. And so he used it to pay off some credit card debts. They went on a vacation. They paid off some expense. They just used the money, and it was spent. And you would have thought that given that he received it as a gift, that he'd get a credit for that. After all, the family situation, I suppose, was improved by the gift that he received from his parents. But sadly, no exemption because it wasn't traceable into an existing asset. Whereas the wife, she could take that investment, she could go buy a rental property, rent that out for a while, decide that she doesn't want to be invested in real estate, sell that property, put it back into an investment fund or mutual fund. Leave that for a few years and take the money out, put it into a business. That's what we call traceable. In each case, the money is traceable into the new asset. And again, that exemption is preserved, subject to, again, this idea that the increase in value may not be subject to division. And that's another point I wanted to mention is that the idea is that the going back to the idea of equal division, the the division happens as of the date of trial, which can be many years after the parties separate. And that doesn't make a whole lot of sense to some people, in fact, many people. And so question happens is, well, does the after acquired property, the property you acquire after the breakup, is that property that has to be shared? And the short answer is yes, but the longer answer is, well, it's going to be subject to some other kinds of consideration because it may not be equitable. But the basic rule is, yeah, it's shared because we do the division as of the date of trial. So I think there's some rationale for that rule. It may be that it's a way to encourage people to settle their affairs quickly rather than letting things drag on. So that doesn't, as some of my audience may realize, sadly, family law cases do not always proceed quickly. They can sometimes proceed very slowly. So, anyway, just a point to remember. Okay, so commingling assets, this is very similar, where you put the money into a joint account, just like putting the money into a jointly owned house has the same effect. It is a gift from one party to the other. Okay, so let's go on to the next slide here. So disclosure is a really important issue here, and didn't have a chance to read the full details, but there was a case just recently in Ontario in the last few days where it was actually a case on jurisdiction. So even in a case where the jurisdiction of the court was put in question, the parties had to disclose what they've got. And I think really the idea is the court is going to be making decisions about how things get divided. They're going to be making decisions about financial support between the parties. If they're going to be making decisions about child support, knowing what kind of assets or property are available to each of the parties is part of that issue. Second issue is, well, you can claim that it's exempt, but if you don't say what it is, how does the other side get an opportunity to challenge that is in fact an exempt property? And a lot of our legal system is based on this idea that we tell people what this case is about. We give them an opportunity to respond, and then the judge or arbitrator has the ability to make a decision about the issue, having heard both parties. You can't have that happen if you're not disclosing. And the courts are very, very unhappy with parties that do not disclose, and they can provide some very serious consequences, like striking your pleadings, your claim or your defense, straight um, issuing penalties. We had one that was, I think, $50 a day for every day, or $150 a day for every day that the disclosure is not provided. You can rack up tens of thousands of dollars in fines that way, or penalties, if you want to be stubborn about it. The courts have even occasionally been known to put somebody into jail to think about uh, the choices they're making about disclosure. So the courts really do consider disclosure to be fundamentally required in family disputes. So, and again, going back to that example of the guy who rolled the dice on the lottery winnings and thought, well, maybe maybe if if I have to, if it's found out, then maybe I'll have to share half. Court did not like that kind of strategic gambling behavior, so to speak, and ordered the husband in that case to turn over the entire lottery winnings to his wife. And that was because of lack of disclosure. So disclosure is really important to the court. It can result in losing your exemptions and losing property and other more significant points. Okay, so how do you protect your assets? And I know we're running out of time here for this. We can protect your assets with a prenuptial agreement or cohabitation agreement. Obviously, prenuptial refers to marriages. That's the nuptial part of that. Cohabitation agreement is a way to deal with parties who are recognizing they've got some property and they want to get into it. They want to start living together. And the real value of these kinds of agreements is a couple of things. One is it clears up some sticky questions that can arise later. Number one, what property are you bringing into the relationship? Which, of course, you have to disclose even when you're negotiating an agreement. Disclosure is key throughout this process. So, so it does give an opportunity for the parties to know exactly what each other has and say, okay, all right, we're going to keep that exempt. And it also gives you an opportunity to kind of tweak the rules a little bit and say, okay, this one's exempt and you get to keep not just the basic property value, but also the increase in value of that property. Or you can decide the other way as well. You can say, you know what, we're going to manage our affairs in a particular way, and this is how we're going to do it. I don't see those too often, but I always think, hey, why wouldn't that be a good idea? Say, look, this is how we're going to run got some rental property. This is how we're going to work it. Say before the kids come, after the kids come, who's going to do what, and how we're going to share the proceeds on that. That's all, I think, a good, healthy thing to put into an agreement. And then there's post separation agreements. And there's another one that's not in there, pretty rare, which is after you start cohabiting, after you've already or after you're married, can you put into an agreement in place at that point? The answer is yes. I think it's a little trickier because the agreements, again, you're going to have full disclosure. You're going to have independent legal advice. And I think you really do have to have a clear idea as to why you are entering into an agreement before there's even any talk of separation. So this is after the relationship starts, before the separation. Can you do an agreement? Yes, nothing preventing you from having an agreement. Post-separation agreements, in particular, these are the ones that require some kind of enforcement after the fact. As I mentioned in the opening remarks, um, you could just divvy everything up. Don't tell the lawyer when you sell the house. Don't tell the lawyer that you're separating. Ask the lawyer to split the money 50-50, or just have the money paid to one party and the other party pays out the other. Nobody knows. I mean, the courts aren't going to go around and poke at people and say, "Hey, are you getting independent legal advice before you go and actually divvy up your property? You want to take the toys, divvy them up. You've acquired your cottage and your quads and all that kind of stuff, your fancy cars, your trailer home, all of those things. The parties are certainly free to divvy everything up to their satisfaction. And if you think there's going to be some risk that somebody's going to change their mind, get an agreement, get independent legal advice. If it's going to require future division, like we're going to sell the house in the spring when the market improves, we're going to list it for sale, get an agreement, and the agreement requires independent legal advice. Okay, so those are the good way to protect your property at various stages of the relationship. I'm going to talk about there are some unique situations. RRSPs, pensions, and non-registered investments. What makes them unique is um, uh, the different ways of valuing them and the different ways that they have different tax treatments. So I really shouldn't have put them all in one bullet point because they really are quite different here. RRSPs, there's the taxes were paid when they were purchased. Sorry, there was a tax deduction when they were purchased. So you got it, and you sell them, you have to pay tax. So quite often what we see is an equal division or some other division of the RRSPs. If it's not an equal division, then you've got to start considering how the tax consequences play into that when you're also dividing taxable assets, the non-registered investments. Pensions can be difficult to value. There's two basic kinds of pensions. There's a defined benefit pension and there's a defined contribution pension. They both have very different valuation rules. The defined benefit pension is one that probably needs the valuation done by an actuary, an expert in this area. Don't just rely on the statement you get from the pension administrator. There are also different rules that are applied in some government-related pensions that can be a little tricky. So that one in particular, if there are pensions, you got to get expert legal and actuarial advice. Business valuations, tax implications, family-owned businesses, businesses that are, closely held corporations where you need all sorts of problems with valuation. What's the value of a business? Well, it's technically it's not the book value. It's the value of what somebody is willing to pay for it in an open market. This can be particularly troublesome in situations where you've got a professional who has a professional corporation, and really the business has no value other than its assets. It has no what we would call goodwill. If the person is no longer employed by or dies. So some businesses have really can anyways, there's just different valuation considerations, different kinds of businesses. Again, don't try to divvy up a business without expert advice, and don't just accept what your spouse is saying about his or her business interest, because there's lots of room for fudging the valuation. So, buying out shared property, again, there's some interesting issues there. Is do you take the cost of disposition, um, the commissions, sales commissions? Is that a deduction if you're not actually putting it on the market? Well, the answer is it depends. And so get legal advice. Matrimonial home. Oh boy, what a big issue there. Do you who gets to stay in the home? What happens if you can't buy the property? There's a bunch of issues there. We're running out of time. You got to get expert guidance for complex assets that, as are described here. So, um, key takeaways, full disclosure. I can't stress that enough. If you have any questions about disclosure, talk to your lawyer about it. A lawyer can sometimes help find assets that you may have lost track of. There's also the full disclosure is so important. Planning on how you do this, how you deal with gifts is also important. Matrimonial agreements or property agreements are also important. So, understanding what is and isn't exempt. I think that's important, because there's a lot of confusion on that. And again, always get legal advice on this issue. Don't just rely on your own. Hey, well, I think it's exempt because after all, I bought the thing and it's mine. The title's in my name. No, that's not an exemption. Okay. Seek professional advice for agreements and valuations, whether they're business valuations or pensions. And again, got to stress this, always disclose all assets fully. You're giving yourself any favors by being resistant to disclosure. And there's ways of forcing. If it's the other side that's having the problem, then you can force them to disclose. Okay, so here's a big message. Empower yourself with knowledge to protect your future. I got to shout out to Catherine. She suggested that as a great closing note. Thank you, Catherine, for that. Good. I think that's great. Empower yourself with knowledge to protect your future. Great that you're here listening to this or watching this webinar. And just remember, this is just the first step. It's just scratching the surface on a lot of this stuff. So now I think we have some time for questions and answers. Q&A.
Wonderful. Thank you, Charles.
Okay.
First question. We have timeshares acquired during marriage. Purchase price was paid off, but contract requires payment of annual maintenance dues. Neither of us wants to keep them, but I think we need to split the timeshares and future burden equally. During 2 years since separation, I have paid maintenance dues. Am I right to expect I can recover half the dues paid since separation and split the responsibility equally going forward? Does anything change if the timeshare contracts are not in both of our names?
Yeah. Okay. So here's some basic principles. Okay. Um, any kind of agreement that the parties reach is not binding on third parties. And so the timeshare company is not bound by an agreement unless they accept the agreement. And so they can agree to accept it. Okay. But that's one principle. Secondly, I think you have to decide what it is you want to do with the timeshare, because it's a liability, these ongoing payments that you have to make, but it's also an asset. And if somebody isn't using the asset, even though they could, um, they're not going to be too keen about paying. And the other party say, well, you know, your name's on it, you're liable. In that case, it's probably something that you need to get rid of because it's not going to work on a long-term basis. What happens if one person wants to use the timeshare more than the other one? How does that work into it? Again, it may be that in the course of resolving these disputes over the timeshare, the simplest way would be simply to unload it. However, as people may recognize, unloading timeshares may be difficult, and unfortunately, that's just the reality of the situation. So, no good answers on that, but that gives you some kind of a starting point, hopefully.
You mentioned asset split happens at date of trial, not separation. Would
Mhm.
that include my pension funds provided by my employer since separation?
Ah,
Uh,
yes.
just a little bit more detail. Hold on. Ex-spouse. I'm sure you get asked that a lot, Charles. Ex-spouse has been delaying divorce since separation 2.5 years ago. This delay tactic seems to continue to work in her favor in many ways.
You know, this is where you need expert advice, and quite frankly, I may get this answer wrong. Okay, so but I will tell you a basic principle that the valuation of the pension is really dependent upon the years that the pension was in place and the relationship was in place. Okay, so you get married, one party gets the pension lasts for 15 years, and or 15 years later, say the parties separate and the pension continues to play to there continues to be contributions to the pension. So the pension division is a little different than that division at trial because it's only the contributions during the course of the relationship. Although I might be wrong on that, it's one of those things because what we do is we see it in the way the pension uh, orders are drafted. It's important for the pension administrator when they're dividing up the pension as to what the date of separation is. So now that's one part of it. The other part of it is that even after that, for the purposes of the pension valuation, the pension may actually be increasing in value post separation. So I when we have a pension case, what we tend to do is get there's a few lawyers in town who actually specialize in this area. Um, it's a very, very tricky area. And so I don't want to, this is one in particular, I don't want to give a wrong opinion. That's basically my understanding of how the system on pensions works. But we often pull in those pension experts, the lawyers, to assist just with the pension division issues. You can make the other part of pension is that the parties can make various elections at the point of retirement. So what do you do when one of the parties has actually retired prior to separation? That's another complicating factor in terms of how they've made their elections. Often there are elections even if the pension has not been if the parties haven't separated or the one party hasn't or the pension holder hasn't retired, there's elections about how the pension can be paid out. So for example, do you pay out the pension to both parties once the retirement kicks in, or do you pay to one party until they're deceased a one amount, and then after they're deceased, then their partner gets a pension after they die? Do they both get a pension before they die? Those are pension election questions that are you got to have a financial planner at the very least, somebody who really understands how pensions work and how they can be divided. And again, depending on the nature of the pension, if it's a defined contribution, it's a lot easier to value, a lot easier to divvy up. Defined benefit plan, more difficult to value. And when it gets divided, it it tends to be into locked in funds. And again, so there's a lot of moving parts on pensions. That's just a very brief overview.
Okay, thank you. I was a stay at home parent when we purchased a house. My wife claims she received some money from her parents for the down payments, which she is claiming as exclusion. I worked hard to maintain, repair, and renovate the house for the last 1 decade. Is the money she received from her payments for down payment excluded property? Also, the house is only in her name.
Um, Well, it's interesting. It depends on when the it probably doesn't depend on when the gift was received. Was a gift from the parties from her parents, it's probably exempt if she can prove what it was, right? If she can prove what the value is. If she can't prove how much it was, then she might have some difficulty. The fact that there's a stay-at-home spouse, that doesn't make any difference. Going back to that notion of constructive trust, the idea is that regardless of whether the spouse is working or not, they are deemed to be making an equal contribution. So, in the absence of any kind of agreement, that the increase in value of the asset is matrimonial property, and is further strengthened. That view is further strengthened by the contributions that the stay-at-home spouse makes to the home. But those contributions are deemed to be equal to the financial contributions. Just a little side comment. Um, Oftentimes, when you find that it is the non-traditional um, spouse that has the assets, I mean, we talk about traditional marriages. The husband is the one that has all the money, and the wife is the one that stayed home and has no money. That's the traditional view. Lots of situations where you have non-traditional arrangements where the parties decide for lots of good reasons that it's going to be the husband who's going to be the stay-at-home dad because the wife is a higher income earner, for example. That's one really common one. Or you get, say, lesbian relationships or same-sex marriages or relationships. And sadly, it seems like a lot of guys understand that they've got to share their property. It's been around long enough that in that traditional marriage sense, yeah, you got to share the property and move on. We sometimes see those attitudes of wanting to hang on, but not very much. When the genders are different, we see a lot of those um, attitudes of, hey, wait, this is my money. I earned it. I brought it in, I brought home the bacon and bought the house and it's in my name. I should get it. Yeah, unfortunately, the rules are the same regardless of gender. But it's just interesting. We just see that kind of different dynamic at play in those cases. But it doesn't change the actual law.
I have a couple of LIRAs. How are they divided up?
No idea. Okay, so again, this is when I say that because there are tax consequences for different kinds of assets. For example, RSPs, I mentioned dividing them up, that they are uh, you can do a spousal rollover, so there's no taxes. So it just carries on, and that's probably the easiest way to do it. I don't know what the rule is for a lira, so for everybody's benefit, that's a locked-in retirement account. So it's kind of like a pension. And I don't know what the rules are for dividing liras. What the tax consequences are. It may be the simplest way to divvy it up is uh, divided up equally, or if it can be calculated to be offset with other assets, the person who has the lira keeps the lira, and the other person gets more assets of a different sort.
My partner was in a vehicle accident prior to our separation. She was an additional driver under the insurance in my name at the time. Since then, she was awarded a long list of services paid for by the insurance company, including but not limited to health and therapy, but also household cleaning, cooking, and other services. This continued for a long time and added up to a considerable amount. This shows up on my insurance and probably also contributed to the increase in the amount I have to now pay. Would this be something that my partner should disclose, and is it considered matrimonial property?
Well, disclosure is the fundamental rule. The whether it is exempt from division in that particular case, that's another one I don't know because I can think of some arguments as to why it should be considered as matrimonial property. Um, so on the just for example, household um, um, it's house cleaning. That's the housekeeping. Housekeeping is the head of damages in a personal injury claim. Well, I doesn't it reflect the division of labor between the parties? And if there's compensation that's given to one of the parties for a deemed household contribution, and it's the other party that's been doing the work, don't they have a claim on it? I think that's a valid question. I haven't looked at the law. I haven't had an opportunity to have it litigated to give me that opportunity to do it. But it does seem to me that there's some claim for it. Um, a very, very fact specific. You might have a bit of the other thing. It sounds like the monies they've been paid out over time rather than as a single lump sum. So then the question is it really an asset or is it income? And sometimes it's hard to tell whether something is an income or an asset. If it was compensation for future care, then it's probably exempt from division because the care is for the injured party. If it is for future housekeeping services, it's probably exempt from division. If it is um, uh, compensation for future income loss, it may or may not be divisible. If it is as property, if it's compensation in a lump sum for past income loss, it probably is divisible. That's kind of my understanding of it, subject to whatever weird nuances in the law might come along from time to time. Is a lot of areas, a lot of law changes from time to time, and that's just the way things are.
If the husband made the down payment for a house during the marriage and had an agreement with the wife regarding the percentage of ownership, such as 70% for the husband and 30% for the wife, will the property be divided based on this agreement if they divorce, or will it be split 50-50?
Depends on whether the agreement was enforceable or not. Okay, that's where if it complied with section 37, section 36, one of those two sections, one of the last sections of the Family Property Act specifies what the requirements are for the agreement to be enforceable. Parties are free to enter into agreements for something other than what they might be otherwise entitled to, because for whatever reason, it seems fair and reasonable to them. The question about whether a particular agreement is enforceable is a different kind of question because we look first, was there independent legal advice? Was there some defect in that advice? Like, was there a real problem with the disclosure? And again, that is very fact specific because theoretically you can agree that fine, I agree with the disclosure, but that's such a bad agreement. The disclosure is so important. You can reach an agreement, but if you don't know what you're actually giving up or what you're gaining by the agreement, doesn't that really undercut what the value of the agreement is? I say that kind of in a philosophical sense. So I think that one has to be careful about a blanket statement. Yeah, this agreement is enforceable. The courts like to enforce agreements. They're going to bend over backwards to find an agreement is enforceable because we have this fundamental belief in our society that we have freedom of contract. You can make whatever deal you want to make. And the court's not generally not going to inquire as to whether it is a good deal or not, right? Because you're presumed to be intelligent enough to decide whether you like the deal or not. Now, there's there are all sorts of cases where agreements have been challenged and set aside. And there's one Alberta Court of Appeal decision that's said, the lawyer was prima facie negligent for not getting a $5,000 retainer to provide independent legal advice on an agreement. And parties are going, what? I just wanted to get the lawyer to sign off on this agreement. We had negotiated it all. That's how serious the Court of Appeal was regarding this idea of getting proper independent legal advice, because you want to make sure that these agreements are going to be fair and reasonable, even if they are something other than what you might otherwise be entitled to. So sorry, I can't give a clear answer, and I'm going to fall back to my opening remarks. This is not legal advice. Please don't rely on anything I say in these things. This is for public education purposes. A word from our sponsors. So,
Let's see if we can get through the last two.
okay.
Uh, Related to assets division happening at the date of trial. Does this mean that if my spouse delays division for years, during which I do my best to save, these amounts saved after separation but before division are considered matrimonial property and will get divided? I'm working hard on saving while the other party is spending all earned income, as far as I can tell. So I hope that we've
Yeah.
misunderstood this and it's not the case.
This is where I think it really depends. And, just my gut would be telling me that you got a pretty good argument there. But again, the presumption is equal division. That's what the basic underlying rule is. It's a presumption. But the court's obligation is to divide it equitably. And oftentimes, we think that post-separation acquisitions of property don't really fit into that equal sharing point of view, right? But um, if there's, a bunch of considerations on that, and just by way of comparison, I practiced in Ontario a long time ago, back in the 90s, and then I came out here. And Ontario had a different rule. It said date of division date of valuation for division purposes is the date of separation. So there'd be arguments about what the actual date of separation was, because that had a very big impact on it. And a lot of people instinctively think that's what the rule should be, especially if you start reading stuff on the internet. You got to be careful about getting legal advice from the internet, because different jurisdictions have very different rules about property. Property under Canadian law is a provincial jurisdiction matter. So Ontario and Alberta are quite different in that basic presumption. So, um, and then here's the other thing is, how do you actually value the property on the day of trial? Well, you set your trial dates months before, sometimes a year or more before you actually have the trial. And you've done your disclosure a year and a half before then. And so you update your disclosure, what, a few months before? Or do you update your disclosure on the day of trial? What happens if you've got investments in the stock market where the value is going up and down? And the value is as of the date of trial. What are people running out at the lunch break to check on the value of the stock price? At some point the inquiry sounds a little silly when we start putting it that way, but the judge's task is to divide it up equitably, and that doesn't necessarily mean equal. So the judge has to make a reasonable decision based on all of the factors that are before the judge.
Thank you. Now it's 8:02 p.m. There is a last one here that looks like it might be quick.
Okay.
Would you like to answer it? It
I'm
says,
I'm happy to stay a little bit longer. Okay.
thank you so much. So it says, how does a car lease get split in a divorce?
Yeah, remember what I said earlier? A an agreement between the parties is not binding on the third party, the lessor, right? The lessor owns the vehicle, not the party. Now, it depends on the kind of lease it is. If it's a finance lease or a whatever the other kind of lease, non-finance lease. Okay, there's two kinds of leases. One is a lease that is intended to uh, basically leave you with some residual cash value in the vehicle at the end of the lease, and you can buy out the the car for that, or the vehicle for that price, or its fair market value. Other kinds of leases are calculated to basically take the value of the vehicle down to zero, and so the 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 lease itself may actually have a cash value because you have the right to acquire the property, or the property becomes yours at the end of the lease. And it has that, there's some residual value in there. So it really depends on the lease. And hopefully that was a clear answer, but it was short.
Right. Thank you very much,
Okay.
Charles. And thank you, everyone who attended and made this a success with your good questions. And I hope that this was helpful. Again, my name is Vanessa Brahmakshatriya. I'm with the Canadian Centre for Men and Families, Alberta. And please visit our website, ccmfalberta.ca. And if you type in ccmfalberta.ca/programs, you can learn more about uh, the different educational offerings that we have for law, for parenting, for mindfulness, and other things, and the different recovery programs and counseling that we offer. And it's also possible to apply and sign up for a 30-minute free consultation with Charles for your legal matter. And I wish you all the very best. Good night's sleep.
And I just wanted to say, yes, I just put up a couple of links in there. If you want to take a screenshot of that, you can see some stuff. There's other resources there as well. And then yeah, contact CCMF if you want to get that free 30 minutes. Otherwise, you have to pay for it. So there you
In,
go.
in particular, visit that YouTube channel. That's Charles' YouTube channel for all of these webinars like today's. And so if you didn't get the answers you were looking for in this webinar, there's a good chance that you'll be able to find them in one of the recorded ones on YouTube. And if you'd like to hear me introduce him more or less the same way at the beginning of the session, you can. All
Your
right.
introductions are always great, Vanessa.
Oh, bless your soul. They're mostly the same. And it's always a pleasure working with you. Thank you and good night.
Super. Thank you.